Subscribe to our YouTube channel and press the bell icon so that you never miss any video lesson from RAU'S IAS Study Circle.
Hello and welcome to Daily News Simplified, an analysis of the Hindi newspaper from UPSC perspective. Today we will discuss the Delhi edition of the Hindi newspaper dated 11th March 2022. And the articles that we will discuss today are displayed on your screen. So let us start the discussion. This article on page number 2 talks about the civic bodies elections that are going to be held in the Delhi. In Delhi, there are three civic bodies, that is the South Delhi Municipal Corporation, the North Delhi Municipal Corporation and the East Delhi Municipal Corporation. And the elections for these corporations are due in next 5 to 6 months. Now the issue here is that the notification for the election to all these corporations are being delayed because the center is planning to unify all these three bodies into one body. And that is why it is being speculated that such kind of unification is going to take about an year. That is why the elections to these corporations might get delayed because of this proposal of unification. And this is because the center will have to introduce a law into the parliament. And that is why this news on page number 2, that is civic bodies unification, at least a year-long project. And this is likely to delay the elections that are to be held to these municipal corporations that exist currently in Delhi in the form of SDMC, South Delhi Municipal Corporation, EDMC, East Delhi Municipal Corporation, and NDMC, that is North Delhi Municipal Corporation. In this regard, civic bodies in the urban areas are part of the constitutional scheme. And the 72nd and the 73rd Constitutional Amendment Act provided for the provisions of the creation of Panchayati Raj institutions at the rural level and also urban municipal bodies at the urban level. And that is why this becomes an important part for us from General Studies paper 2 point of view in the mains examination, and also it is a very important topic for us from the prelims examination. If you look at the previous year question papers, regularly questions have been asked regarding the performance or the issues that are faced by these local bodies. So the question that was asked in 2018 was about assessing the importance of panchayat system in India as a part of local government. And in this question, we were required to analyze the issues related to financing of these Panchayati Raj institutions at the local body level. If you look at the 2017 question, it read, the local self-government system in India has not proved to be an effective instrument of governance. Critically examine the statement and give your views to improve the situation. That is, we had to identify the issues in the local self-government, the issues in its functioning, and the measures for improvement. Further, if you look at the question that was asked in 2015, it reads, in the absence of a well-educated and organized local level government system, the panchayats and the samitis have remained mainly political institutions and not effective instruments of governance. Critically discuss. So all these three questions that have been asked in the previous years highlight that Panchayati Raj institutions and urban local bodies are important for us from the exam perspective. And an analysis of all these is really important for us from the mains examination perspective. However, we are aware that prelims is approaching. So let us look at the provisions related to urban local bodies that are provided for in the Indian Constitution, which can be important for us from the prelims examination perspective because of this current affair that is in news. And after we discuss the provisions which are important for us from the prelims examination perspective, we will revise from a previous DNS video where we have discussed the issues in the functioning of the urban local bodies and also the issue of finances of the urban local bodies based on a report that was published by Reserve Bank of India. Now, if you look at the urban local bodies and the constitutional provisions related to these urban local bodies, the 74th Constitutional Amendment Act provided for the formulation of urban local bodies in India. And this Constitutional Amendment Act, which was brought about in 1992, added Part 9A to the Indian Constitution. So this aspect can be a very important aspect for us from the prelims examination perspective because it is in the nature of a factual information that Part 9A provided for urban local bodies. Then if you look at the articles related to the urban local bodies, these range from Article 243P to Article 243ZZ. The 74th Constitutional Amendment Act added 12th schedule to the Indian Constitution, and this schedule contains 18 functional items of the municipalities, that is the functions that can be devolved to these urban local bodies. And the article that is related to the functions and the 12th schedule is Article 243W. So this again is an important information for us from the prelims examination perspective.
Now, important change that was brought about by this Constitutional Amendment Act was that the urban local bodies became constitutional bodies. And in this regard, the state governments were now under constitutional obligation to adopt the new system of municipalities in accordance with the provisions of the Constitutional Amendment Act. That is, for an all India level, a structure was provided for by the constitutional provisions, and all the state governments were constitutionally obliged to create these urban local bodies based on the provisions that have been provided in the 74th Constitutional Amendment Act. In this background, related to the urban local bodies are various provisions related to the composition of the urban local bodies, the tenure, the functions, finances of these urban local bodies, and these exactly are the issues that are also faced by these urban local bodies. So let us first look at the preliminary examination related information related to all these aspects of the urban local bodies. Now, in all the provisions related to either the Panchayati Raj institutions or related to the urban local bodies, you always need to understand which all provisions that are provided by the Constitution are of compulsory nature or which all provisions are of voluntary nature. In this regard, with regards to the composition related to this, if you look at the compulsory provisions, the Constitutional Amendment Act of 1992, that is the 74th Amendment Act, provides that all the members of the municipality shall be elected directly by the people of the municipal area. So this is in the nature of a compulsory provision that has been provided. That is, all the members of the municipality shall be elected directly by the people of the municipal area. However, there are certain voluntary provisions also related to the composition of the urban local bodies. What are these? So first is that the state legislature may provide the manner of the election of the chairperson of a municipality. That is, the state legislature will decide if the chairperson of the municipality will be elected directly or will be elected indirectly by the members of the municipality. So this provision or this authority has been provided to or has been left with the state legislature to decide upon. That is, it has not been provided in the constitution directly. So this becomes an important thing, that this is not a compulsory provision. That is, the manner of election has been provided in the hands of state legislature, and they will decide how the chairperson of a municipality will be elected. Then besides the provisions related to the election of the chairperson, the state legislature has also been provided certain rights regarding the representation of other people in the municipal bodies. That is, the state legislature may provide for representation of persons having special knowledge and experience in municipal administration without the right to vote in the meetings of the municipality. That is, it is not compulsory on the state legislature to provide representation to these people, but if they think it is important, they can provide these people with representation, however, without right to vote. Second is that it can provide for the members of the Lok Sabha and the state legislative assembly who represent these constituencies that comprise wholly or partly the municipal areas. That is, the members of the Lok Sabha and the state legislative assembly who fall in the municipal area or who are part of the municipal area can also be provided representation in the municipal bodies. Third is that the members of the Rajya Sabha and the state legislative council can be registered as electors within the municipal area. And finally, the chairpersons of the committees can also be provided representation in the municipal bodies. So these all provisions are in the hand of state legislature. That is, they will decide upon these provisions. However, regarding the members of the municipality, they shall be elected directly, and the state legislature does not have anything or any power related to this provision. That is, they can never let the members of the municipality be elected indirectly or in any other manner. So this is how you divide the provisions into compulsory as well as voluntary provisions. Related to this are the provisions related to ward committee. Now, regarding the wards committee, the compulsory provision that has been provided for in the constitution is that there shall be constituted a wards committee, and this will consist of one or more wards within the territorial area of a municipality having population of 3 lakh or more. So this is the criteria that has been used for the creation of wards committee. In case the population is more than 3 lakhs, in that case a wards committee will have to be created, which will consist of one or more wards within the territorial area of the municipality. So this is a compulsory provision that has been provided for in the constitution. In this regard, certain voluntary provisions, that is provisions in the hand of the state legislature, that is, it is to the discretion of the state legislature if they want to decide upon these provisions. These are known as voluntary provisions. So with regard to ward committee, the state legislature may make the provisions with respect to the composition, the territorial area of a wards committee, and the manner in which the seats in a ward committee shall be filled. That is, they can decide upon the manner in which these seats will be filled in the ward committees. Further, it may also make any provision for the constitution of committees in addition to the ward committees. That is, it is not necessary that only ward committees can be created. Beyond the ward committees, they can create any kind of special committee related to particular municipality. So this is in the discretion of the state legislature. That is why these are voluntary provisions. They can make the provision for the composition, how the ward committees will be composed, the territorial area under that will fall under the ward committee, and every other thing related to manner of election to these seats or manner in which the seats shall be filled. All these will be decided by the state legislature. However, ward committee will have to be created, which is a compulsory provision if the population is more than 3 lakh or more. Now, with regards to the reservation of the seats, there are also compulsory provisions that have been provided for in the constitutions, and there are provisions which have been left to the state legislature to decide upon. So regarding the reservation of the seats for the scheduled castes and scheduled tribes in every municipality in proportion of their population to the population in the municipal area. So this is a compulsory provision, that is the reservation for the seats, the reservation of the seats for the scheduled castes and the scheduled tribes has been provided for in a fixed criteria or in a fixed manner, which is a compulsory provision. Second is that reservation to women have also been provided regarding the seats. That is, reservation of not less than 1/3 of the total number of the seats will be for women. So these are certain compulsory provisions. Further, the state legislature may provide for manner of the reservation of the offices of the chairpersons in the municipalities for the SCs, STs and the women's. So how or which all municipalities will be reserved for the chairpersons from the SC, STs and the women will be decided by the state legislature. So this has been left to the discretion of the state legislature. Further, the state legislature may also make any provision for the reservation of the seats in any municipality or offices of the chairpersons in municipalities in favor of backward classes. So the reservation for backward classes has not been provided for in the Indian Constitution in a compulsory provision. However, reservation for scheduled tribes, scheduled castes and women have been provided for in the compulsory provisions in the Constitution. However, on the matter of decision related to reservation for backward classes, the seats reservation for backward classes, so it is in the discretion of the state legislature that they can decide upon this issue of providing reservation to the backward classes also. And also regarding the manner of reservation of the offices of the chairpersons in the municipalities for SC, STs and women. The next thing that we need to understand is regarding the duration of these municipal bodies. So first, all the provisions related to duration are compulsory that have been provided for in the Indian Constitution. First is that a 5-year term of office for every municipality. Now, what used to happen before the 1992 Constitutional Amendment Act was that the municipalities, once they were dissolved, elections were not held regularly by the state governments because everything was in the hands of the state governments or in the hand of the state legislature. That is, everything was at the discretion of the state legislature. That is, in the past, the state legislatures delayed the election to the municipal bodies. However, now the election of the municipal bodies or the urban local bodies have been made compulsory by the Constitution. In this regard, the first provision is that the term of the municipality will be 5 years. However, there will be cases when the municipal body can be dissolved before the completion of this 5-year term. In that case, fresh elections to constitute a municipal body shall be completed before the expiry of its duration of 5 years. And second, in case of a dissolution, before the expiry of a period of 6 months from the date of its dissolution. So in case the municipal body is completing its 5 years, in that case, before the expiry of its duration of the 5 years, the elections shall be completed by the State Election Commission. However, if the dissolution of a municipal body has taken place before the scheduled term of 5 years, in that case, elections will have to be held before the expiry of a period of 6 months from the date of its dissolution. So let's say if the municipal body has been dissolved on 1st January 2022, then the elections will have to be held before the completion of the 6 months from the 1st January 2022. That is the elections will have to be held before 1st July 2022. So this is one important criteria that has been provided for in the Indian Constitution. Now, there will be circumstances when the municipal body has completed around 4.5 years and only 6 months are left for its completion of the 5 years. However, after the completion of the 4.5 years, because of any political issue, the municipal body is dissolved. So, what will happen in that case? In that case, where the remainder of the period is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality for such period. That is, it can remain suspended for that remaining period of the term. So, in case a municipal body has completed 4.5 years and only 6 months are left, for its completion, and during this period of 6 months, if the municipal body is dissolved, in that case, it is not necessary to hold new elections for these remaining 6 months. So, that is also one important provision that we need to be aware of. Then there will also be another scenario where, let's say, if a municipal body has completed 3 years and now it has been dissolved. So, in that case, the elections will have to be held for such municipal body, but the newly chosen municipal body will remain in power only for the remaining 2 years period, which was left for the overall completion of 5 years term. That is, a municipality that is reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the. That is, when the municipality got dissolved after the completion of the 3 years, new elections were held and a new municipal body was appointed, it will remain in power for only the remainder of the period. That is, not for a full period of 5 years like what happens in cases of state legislative assembly or in case of the central government. So this is one unique provision related to duration of the municipal bodies. So these are all really important for us from the prelims examination perspective. And all these provisions related to the duration are compulsory in nature. Then there are provisions related to powers and functions, finances, as well as related to district planning committees. In this regard, one of the flaw that has been left by the Constitution of India is that the powers and the functions which should have been devolved to the municipal bodies and the Panchayati Raj institutions has been provided for in the hands of the state legislature. That is, no compulsory powers or functions have been provided for in the Indian Constitution. And that is why this has been the case that the state legislatures have been reluctant to devolve the powers and the functions to these local bodies. So this is one of the issues also that is being faced by the urban local bodies as well as Panchayati Raj institutions. So in this regard, regarding the powers and the functions, the voluntary provision is that the state legislatures may endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government. However, as we all are aware that the state legislatures are at times reluctant to devolve these powers and authority as well as functions to these bodies. So this is one of the issues also, and that we need to be aware of from the preliminary examination perspective. That is, it is not compulsory in the Constitution to provide for the functions or power or the manner in which the power will be exercised by these municipal bodies. This is in the hand of the state legislature. The compulsory provision is related to duration and the composition. Another issue related to municipal bodies is related to the finances. In case of finances also, no compulsory provision has been provided for in the Indian Constitution. In this regard, the state legislature has been provided the discretion of providing or authorizing a municipal body to levy, collect and appropriate taxes, duties, tolls as well as fees. So if you compare the taxation system and the powers that have been provided to the central government and the state governments, all these provisions have been incorporated in the central government. So the taxation and the distribution of the taxation has been provided in the constitution itself. That is, the state government has certain taxes under its control, while the central government has certain taxes under its control. But that is not the case in case of municipal bodies, because the state legislatures will decide upon which taxation powers are to be provided to the municipal bodies. That is, the state legislature may authorize a municipality to levy, collect and appropriate taxes, duties, tolls and fees. Further, the state legislature may assign to municipality taxes, duties, tolls and fees levied and collected by the state government. Third, provide for making grant in aid to the municipal bodies from the consolidated fund of the state and provide for constitution of funds for crediting all the monies of the municipality. And because the finances are largely under the control of the state legislatures, the urban local bodies are always starving of finances. This you will look in the later part of the discussion, that finances are also one of the issues and the challenges that is faced by the urban local bodies. Then another important provision in the Indian Constitution related to the urban local bodies is related to district planning committee. In this, there are certain compulsory provisions, while there are certain voluntary provisions or the provisions that have been left in the hands of the state legislature. So regarding the compulsory provision, it is that every state shall constitute at the district level a district planning committee to consolidate the plans that are prepared by panchayats and the municipalities in the district to prepare a draft development plan for the district as a whole. So in a particular district, we all are aware that there will be panchayati raj institutions as well as municipal bodies. So in this case, this district planning committee, so in such cases, the district planning committees shall be constituted at the district level, which will play an important role for the finalization of the district development plan. And this will be made through, or this will be ensured through the participation of both the panchayats as well as the municipalities under this district planning committee. In this regard, certain provisions have been left in the hand of the state legislature regarding the composition of these district planning committees. That is, the provision related to the constitution or creation of the district planning committee is a compulsory provision. However, the manner in which it will be constituted has been left in the hand of the state legislature. So the state legislature may make provision with respect to the following, that is, the composition of such committees, the manner of election of the members of such committees, the functions of such committees in relation to the district planning, and the manner of election of the chairpersons of the such committees. However, there is one compulsory provision that has been provided for in the constitution, that is, 4/5 of the members of this district planning committee should be elected by the elected members of the district panchayat and the municipalities in the district from amongst themselves. So this is a very important aspect that you need to be aware of. Also, the chairperson of such committee shall forward the developmental plan to the state government. So this is also a compulsory provision. But this important provision, that is 4/5 of the members of the district planning committee should be elected by the elected members of the district panchayat and the municipalities in the district. Now comparing this with the metropolitan planning committee that has been provided for in the metropolitan areas. So in that case also, certain provisions are similar to the district planning committee. However, let us look at what is the minor difference. So in case of metropolitan planning committee, every metropolitan area shall have metropolitan planning committee to prepare a draft developmental plan. That is, this is a compulsory provision. That is, every metropolitan area needs to have a metropolitan planning committee. However, regarding the provisions related to the composition, the manner of election of the members, etc., this has been left in the hand of the state legislatures. That is, the state legislature may make provision with respect to composition of such committees, manner of election of the members of such committees, representation in such committees of the central government, state government and other organizations, functions of such committees in relation to planning and coordination for the metropolitan area, and the manner of election of the chairpersons of such committees. In this case also, certain provisions have been provided for compulsorily in the constitution. That is, 2/3 of the members of the metropolitan planning committee or the MPC should be elected by the elected members of the municipalities and the chairpersons of the panchayats in the metropolitan area from amongst themselves. That is, this number is 2/3 in case of metropolitan planning committee, which was 4/5 in case of district planning committee. So this again is a very important provision. Similar to the district planning committees, the chairpersons of the committee shall forward the development plan of the state government. So these are few important provisions related to urban local bodies that have been provided for in the Indian Constitution in the form of compulsory provisions and the provisions that have been left for the state legislatures to decide upon. So we have seen these provisions in the form of a table, that is the compulsory and the voluntary provisions in case of composition, ward committee, reservation of seats, duration, as well as powers and function and finances, and the case of district planning committee and metropolitan planning committee. Now, after looking at the provisions from our preliminary examination perspective, let us revise from a previous DNS video where we have discussed the issues related to the financing of the urban local bodies. Also, let us look at some of the issues that are faced by the urban local bodies in their effective functioning, which can be important for us from the mains examination perspective, because already at the beginning of this video, we have seen the questions that have been asked in the previous years. Let us revise from this previous DNS video. In this line, we all are aware that the urban local bodies and the Panchayati Raj institutions are sometimes said to be the third tier of government that we have, because we have central government at the top level, then we have the state governments, and then we have these urban local bodies and the Panchayati Raj institutions. And the topic of urban local bodies becomes important for us from General Studies paper 2 point of view. In this regard, the Reserve Bank of India has highlighted in a report the state of finances and the study of budgets of 2021 and 22, and it has highlighted that the third tier of the government, that is these urban local bodies and the Panchayati Raj institutions, played a key role during the COVID-19 pandemic because these were the bodies that were at the front line in handling the issues that were generated because of COVID-19. And because these bodies were at the front line in combating the pandemic by implementing various strategies, this led to severe strain on their finances because of increased expenditure and reduced mobilization of funding from various sources because of the various lockdowns that were imposed. And that is why let us first look at what has been the observation of the Reserve Bank of India's report regarding the finances of these municipal bodies or the urban local bodies. And after that, let us look at what are some of the issues associated with the functioning of the urban local bodies in India. Now, the Reserve Bank of India's report has highlighted that the finances of these third tier governments were impacted during the COVID-19 because of restrictions that were imposed on the movement of the people. It was because of the provisions of goods and services that were to be provided by these urban local bodies because of the lockdowns that were imposed, because these were the bodies which needed to take care of the restrictions that were imposed and all other kind of responsibilities. Further, these are the bodies which had the responsibility of ramping up health infrastructure at the city level. And finally, these bodies also had to take measures to protect the livelihood and also focus on the vaccinations of the citizens during a very short span of time. And all these factors severely impacted the finances of the urban local bodies or the third tier of government as they are called. In this regard, let us look at what are the major revenue sources of the urban local bodies. The first source is, of course, the tax that is imposed by these bodies, which include the property tax, octroi, tolls, as well as water charges. Then the next major source of revenue for the urban local bodies is non-tax revenues, which include fees as well as user charges. And finally, the transfers are also made by the central government and the state governments, including the finance commission at the central level and also the state finance commissions. And if you look at the expenditures of these urban local bodies, these include administrative expenses and the developmental expenses in the form of public services that are provided by these urban local bodies, which include water, sanitation, roads, education, waste management, etc. Now, because the pandemic led to the strain on the finances of these urban local bodies, the report of RBI highlights that various steps were taken by the municipal corporations to fill this resource gap. In this regard, it led to reduction of non-essential expenditure by these bodies, which was one of the measures that was taken by the municipal bodies. Then they also focused on mobilizing additional funding from borrowing by issuing municipal bonds, that is, they've tried to borrow from market. Another source of resources for these municipal bodies were the deposits that were provided by the state disaster response funds. Also, there was issuance of COVID bonds by these municipal bodies, as well as they focused or dependent upon the donations and the contributions that were provided to them from various trusts and organizations in this regard. So this was the overall assessment of how the local bodies functioned during the COVID-19 pandemic, what were the issues that they faced during the COVID-19 pandemic in the form of the financial strain, and lastly, what were the measures that were taken by these bodies. In this backdrop, let us look at what are some of the general issues that are faced by these urban local bodies. Now, if you look at the issues that are faced by these urban local bodies, it is sometimes said that these bodies face the issue of 3Fs. And these 3Fs represent the funds, the functions, and the functionaries. In terms of funds, it is sometimes said that these urban local bodies or municipal bodies face the issue of paucity of finances. This is because these bodies are not able to earn a lot of revenues from the taxes that are imposed by these bodies. Also, there has been lack of or there has been meager transfer of funds from the State Finance Commission as well as the central government. And also, they have not been able to generate revenue from the local taxation. So this is what is leading to paucity of finances for these local bodies, which represents the first F, that is the paucity of funds. Second issue that the municipal bodies face is that India is witnessing rampant urbanization. This is because of the rural-urban migration. And at times, This is leading to unplanned urbanization, and these municipal bodies are not capable enough to handle this unplanned urbanization. And that is the second challenge or issue that is faced by municipal bodies in India. Third issue that is faced by these municipal bodies is the excessive control of the state governments, which represents the second F, that is, there is lack of devolution of functions to these urban bodies or urban local bodies. Second F is represented by the functions, that is, there is excessive control of the state governments on these urban local bodies despite the constitutional provisions that have been provided in the Indian Constitution. This is because there are certain voluntary provisions that have been provided in the Constitution regarding the urban local bodies, which depend upon the state governments to transfer the responsibility on these urban local bodies. And as such, not many important functions have been transferred to these urban local bodies by the various state governments. Further, these local bodies are at times dominated by bureaucrats and not by the people, as was envisioned in the 73rd and the 74th Constitutional Amendment Act while creating the Panchayati Raj institutions as well as the urban local bodies. Now, the main idea of creating this third tier of government was to increase the participation of the people at the grassroots level. However, that has not happened, and these bodies have been dominated by not by the people who have been elected at the ground level, but they have been dominated by the bureaucrats in this regard. So that is also one of the issues that these municipal bodies face. And lastly, if you look at this third F that is related to the problem of municipal bodies, it is regarding the lack of skilled functionaries. Now, if you look at the responsibilities that have been provided to these urban local bodies, these include sewage management, provision of providing water supply, electricity management. All these issues are now responsibility of municipal bodies. But these bodies do not have enough skilled functionaries to handle these issues related to waste management, or let's say providing sanitation and water supplies. That is why the third problem that these municipal bodies face is related to the functionaries. So the three F's include funds, functions, and functionaries. And last but not the least, the main objective of increasing the people's participation has not been seen in the functioning of these urban local bodies. So these are some of the common issues that are faced by various municipal bodies in India or the urban local bodies in India. In this regard, the RBI has recommended that functional autonomy should be provided to these civic bodies, and their governance structure should also be strengthened. And this could happen by empowering them financially through higher resource availability. And in this regard, the second ARC has also recommended that there should be a clear-cut demarcation of functions of each tier of the government. And that is how, if you provide increased funds, improve or devolve the functions to the appropriate level at the urban local body level, and also if there is provision and improvement in the skilled functionaries at the urban local body level, the urbanization process can be streamlined and the various problems that are faced by these local bodies can be solved and they can be made more people friendly. And that is how the goal of the grassroots democracy can be achieved if these three issues of the urban local bodies are solved in the first place. With this, let's take up the next news article now. This article on page number 11 is related to reservation for women in judiciary. In this regard, the Chief Justice of India has called for providing 50% reservation to women in the judiciary in order to provide for gender sensitization of the judiciary. And in present case, especially in case of higher judiciary, there is lack of equitable representation of women in the higher judiciary as well as in the subordinate judiciary. In this regard, if you look at the mains examination paper of 2021 of General Studies paper 2, a question was asked regarding the desirability of greater representation to women in higher judiciary to ensure diversity, equity and inclusiveness. In this discussion, let us try and understand the issue of women reservation in judiciary, that is, what will be its advantages and what are some of the concerns. So as far as representation of women is concerned in the judiciary, presently the system is inadequate, and it was highlighted by the Chief Justice of India that if you look at the representation of women in the judiciary, there is inadequate women representation across judicial offices. That is, women represent only 30% seats in the subordinate judiciary. And as far as the representation in higher judiciary is concerned, it is only 11.5% at the High Court level and 12% at the Supreme Court level. In this background or in this context, the Chief Justice of India has proposed 50% reservation for women. Further, the Chief Justice has highlighted that out of the 37 women that were recommended by the Supreme Court Collegium, only 7 were appointed as judges for the High Court. And pitching for 50% reservation for the women, the CJI has said that the reservation in judiciary will bring constitutional balance between the legislature, executive, and judiciary. It will serve the cause of social justice and equity through equitable representation, and also the first hand experience of the problems faced by the backward members of the judiciary will help in sensitizing the issue and dispensing justice effectively. And that is why the Chief Justice of India has called for reservation of women in the judiciary. In this context, let us look at some of the advantages that will accrue because of providing reservation to the women in the judiciary. Now, if you look at the advantages related to reservation for women in judiciary, it will ensure equitable representation in the courts and will bridge the gender gap. Further, it will help in gender sensitization in the judicial orders, especially for the cases that are related to women, that is, cases related to domestic violence, women's right over property, and cases related to dowry. Because in that case, the women judges will be more sensitized to understand the issues that are faced by women at large. Also, it will help in improving the gender specific infrastructure within the court premises, for example, separate toilets for women. Now, this is specifically pointed out because the infrastructure that exists in the lower judiciary and in courts that exist in India are especially not women friendly. Further, it will help in improving the gender sensitivity even within the court premises, and this especially in the case of the lawyers and the administrative staff that works in the court premises. Also, it will lead to women empowerment in the judicial field because already the provision for reservation for women is provided for in case of the Panchayati Raj institutions and the urban local bodies, and also in cases of certain states, the reservation has been provided for in the government jobs to the women. Also, it will encourage women to pursue law as a career and will boost legal education. And it will help in improving the ratio of women law graduates in the overall graduates amongst women. However, there are certain concerns also related to reservation for women in judiciary. The first concern that has been raised is that the inadequacy of the women reservation needs to be proved at the state level through specific data. Otherwise, it might violate the principles on which the reservation is sought. Second issue is that the appointment process for the lower judiciary varies across the states, and hence it will be difficult to ensure uniformity in reservation for women across the states. Third is that chances of women reservation being utilized mostly by upper caste women is also there. That is why proper representation should be provided to women from SC, ST and OBC background also. Further, let us try and understand how to make the women reservation more effective. In this regard, let us provide certain suggestions. So, we understand that providing reservation to the women is important. However, it should not be considered as the only move to improve the women representation in the Indian legal system. In this regard, one of the suggestions can be women should be encouraged to take up law as a career choice, and then suitable reservation to women candidates must be provided at entry level. Further, if the provisions for reservation are provided in the higher judiciary, there should be another subset which provides for reservation to women from specific categories of vulnerable sections like SC/STs and women from OBC background. Further, there is a need to bring at least one judge in the collegium of Supreme Court and High Court for equitable representation. Also, the state governments must bring a law to provide reservation in the lower judiciary to women and the members of backward classes. And further, we all are aware that one of the suggestions that is provided for is the creation of All India Judicial Service. And in case these All India Judicial Services are created, in that appropriate reservation should be provided to vulnerable sections, for example, women and women from OBC and SC/ST communities. So this is how you look at the issue of women reservation. That is, there are certain inherent strengths in case of providing reservation to the women. However, there are certain issues that need to be focused upon first, and these issues need to be resolved so that the judiciary can be made women friendly and the concerns of the representation of women in the judiciary can be handled more effectively. With this, let's take up the next news article now. Now, this article on page number 12 is related to the 5th National Security Advisor level talks of the Colombo Security Conclave. Now, this gains importance because the members of the Colombo Security Conclave are the members of the Indian Ocean region, and the cooperation amongst these members is important for maritime security. In this context, in the DNS of 14 December 2021, we have discussed the different aspects of maritime security. And this was in news because the Indian Prime Minister had addressed the UN Security Council meeting. And at that point, he had highlighted the importance of maritime security and had also given a 5-point framework for maritime security. And that is why in this context where the Indian government is providing high priority to maritime security, especially in order to counter China in the Indian Ocean region and its theory of string of pearls of encircling India, the Colombo Security Conclave becomes important for us from the prelims examination perspective and especially the members of the Colombo Security Conclave. So in this regard, if you look at the Colombo Security Conclave, it is basically a meeting of the national security advisors of the countries which comprise the Colombo Security Conclave. It focuses on maritime security and cooperation in the maritime sphere. The founding members of this Colombo Security Conclave were India, Maldives and Sri Lanka. Later, Mauritius was also added, and in this edition of the Security Conclave, Mauritius also attended. And the other two members which attended as observers were Bangladesh and Seychelles. So this is how the composition of Colombo Security Conclave looks like. This can be an important information for us from the prelims examination perspective. To understand more about the maritime security, you can go through the DNS of 14 December 2021. With this, we conclude today's discussion, and this is the question for the day.